The next step we're going to talk about comes from the zip file for employee forms in English. Here there are a series of forms that we're going to discuss individually so you understand how they work to prepare you at the door. It is imperative that we protect the door. We must always stand guard at the door of hiring. The problem you have as an employer is the states no longer have the budget or the finances to handle a second injury or subsequent injury trust fund payment that used to protect you and shield you from hiring those that had partial disabilities. Now you are becoming the sole burden of that. Therefore, there's no fund. So who you hire, you just hire your problem. And every problem they bring with you medically is one you'll have to fix at your expense, while they, in turn, are taken care of, no deductible, no copay, and they have a disability income policy to match. It is imperative you're careful who you hire and you match them up to the essential function of the job. I cannot emphasize the essential function enough, and you will hear me repeat this throughout this form set. The first form in the file is to help out at the door. We must do some screening at the door, at the first point before they even become an applicant. And that starts with the light industrial pre-application form. It has 10 questions down the left margin. These questions are to help get you through this process. These can be asked over the telephone on a call-in, or they can be a walk-in on a clipboard, and they answer the 10 questions. The key to workers' comp are the last 5. The first 5 are up to you. None of these are cast in concrete specifically. It's up to you to decide in the first 5 if you approve or if you wish to tinker with those. That's fine. But on the last 5, let's look at number 6. If you're hiring a driver or anyone who has driving capability, they must bring a suitable MVR, motor vehicle record. And you'll check it out, and if they don't have a suitable record, they can't be hired, not as a driver. The key is to bring this out up front so they know what they're getting into and they know what your standards are. If you have a no driving position, they can use NA, which doesn't apply. The next question is about lifting. They must be able to lift weights, a specific weight to the job. The weight you want to use is your maximum weight for production. That's where it'll apply the most. You can go as high as 100 pounds, like for moving companies, firemen, and ambulance people. We typically like 50 pounds. If they cannot handle 50 pounds in a general work environment, then they're not suited for your job. You're bringing this out up front so they know lifting will become a concern, and their ability to lift is critical. The next question will involve a drug test. Are they willing to allow you to do a drug test? You're not saying you're going to do one, but you're saying, if I want to do one, are you willing to let me? Very important question. The drug issue should never be underestimated. The next question is a criminal background check. Are they willing to let you run a criminal background check? You're not saying you're going to run it, but are they willing to let you run it? Very important question. And what will happen on the criminal background check is we have a site that we will provide you access to with a signed waiver where you can run as many as you want, as often as you want, as long as you have a consent form signed. And we'll talk about that form a little later. The last question talks about a 50-mile radius for regular and light duty. This is not that important for regular duty. However, for light duty, it is critical that we have something on paper that they've consented to this before a light duty situation arises, because they could use that as a point of distraction, and they could say, I can't drive 50 miles, you didn't tell me that. So we'll have it on the record up front, and they won't even know it's there. Sneaky? Well, it depends on how you look at it. The system is not your friend, never will be your friend. You've got to look out for you, and we're going to help you look out for you. We're going to go on offense together. We have to screen at the door. That's the first place it starts. All this throws up is barriers. We know the predators, just like electricity, seek the path of least resistance. Any resistance at all, and they will move on, because they really just want to get on payroll. We just want to make sure it's not yours or ours. This form is pretty cut and dry. It is one of those you will cover on the telephone or as a walk-in applicant, okay? Do the best you can with it. There are bound to be questions later. The next form you'll see is the Job Description Essential Function form. This form goes behind your application, directly behind it. This form allows you to use the occupational disease exemptions that you're granted by the state legislatures when they have granted immunity to workers' comp from medical privacy. Workers' comp has immunity. It is a state subject. HIPAA and federal involve life insurance and health insurance, not workers' comp. There is immunity. This form allows you up front at a certain phase to bring this out using the occupational disease check boxes. Be sure every box is checked. However, when you look at this, you're just merely looking for flags. That's all you're doing is looking for flags. You're focusing on the essential function. You do not want to get sidetracked into small trivialities. Stay with the essential function of the job. That's critical to keeping you in line and to making everything flow correctly. What is an essential function? An essential function is that part of the job without which there would be no job. Meaning you could automate the job or you could send it out. You don't even need them. And yet you have no obligation to engineer out fixes for everything. Only reasonable fixes and corrections. Essential functions do not meet that definition. So this form goes behind the application. When it's filled out, you want to look for the circle no answers. Any no answer just simply raises a flag for you. That's all it's about, is a flag. You're not a doctor, but you know what the essential function of the job is. 9 times in 10, your concerns are going to be around the lifting elements of this. It could involve some gripping, grasping, twisting and turning, carpal tunnel issues. Any proclivity for these, this form will help flush out and remind them that we're there looking. These are points that you need to be aware of. It could be safety equipment. It could be understanding chemical MSDS sheets and hazard communication. These are all elements that are deemed to be occupational disease exemptions where you have an out. They must be able to comply with these and understand these. And that's what this is for. When you see a flag on this form, the key is finish the other form. We'll talk about it in just a second. And then you want to talk to this applicant at that phase and remind them, say, look, I see we've got a concern right here about the lifting demands. You know, our job is 50 pounds, and I'm not sure. You see there's a concern. Why don't you take this form to your personal doctor, and if he'll sign off and date approval that you can do this work, I'm okay with that. But I can't make a medical decision, nor will I. But I have a concern. I don't want to put you out on the job and have you get hurt. That doesn't benefit either one of us. So take this to your doctor, come back and see us when you get approval, and we'll move on. That form is a great point where you're no longer in the process of screening. You're going to let them screen. Those looking for an easy in will not even bother. Some of them may go have their sister or brother-in-law fill it out and tell you it's a doctor. Make sure you call back and be sure with a nurse or the doctor that they in fact did see a doctor. There's no telling what they do when they're trying to get on payroll to fix problems. The question is, do you want to be the one to fix it? One rule about work comp: no good deed ever goes unpunished, so be very careful. The next form you see will be the drug test consent and the criminal background check form. This form goes behind the job description essential function form. Whether you have a drug program or not, this form needs to be added. If you have a drug program and you have your own forms, add this to this. These subjects, you can never repeat them enough. You can never emphasize them enough. The drug test consent form is very comprehensive for a short version. The lower half is the criminal background check. I referenced already you'll have access to our criminal background site where you can run your own checks, but you need to have this consent form filled out before you do that. Next, we're going to move into the post-offer medical questionnaire, which is in the same employee packet. This form is critical, and it is important to understand the premise of the form and that you have a right as an employer to know prior medical information. The state legislatures in every state grant immunity to the workers' comp for a reason that the employer must know if someone is physically capable of doing a job. This intertwines with the ADA to some degree. But the physical element of knowing someone can do a job, and that is the essential function of the job. I will restate that one more time. It is critical. Remain focused on the essential function. What is the essential function? I'll define it again. It's that part of a job without which there would be no job. There's no way you can eliminate it without eliminating the job. And this could involve physical elements, particularly lifting and bending and stooping. The weight limits can go up to 100 pounds maximum. A lot of those you see are 25 pounds. We prefer, in a general environment, non-clerical, 50 pounds. If someone cannot handle 50 pounds, that's a concern, because there are different elements of the job, not just the lifting, but force application that could reach 50 pounds. It is important to be sure you have someone who's able. This is in a post-offer capacity, which puts it in the same area as a drug screen and a criminal background check. If you do those and the applicant fails either one of those, you don't hire them. The same thing with the post-offer medical. However, you're not going to play doctor. That's not your role, nor are you permitted to do such. Your role is to be a flag. You're going to look for flags. This form is nothing but flags. The form is set up to cover multiple bases. It's set up for a win-win-win for everybody. First, this form applies to the post offer, and it applies to every existing employee on payroll. You have a right to have a medical file, a medical emergency file, arranged in alphabetical order from every employee. Now, there will be those who will complain that it's private and they don't have to tell you this, but I'm going to tell you that you are granted immunity from this. However, I'm also going to tell you there's no need to argue with these people. Just simply have them write across if they refuse to fill it out and file it that way. That's all there is to it. It's not worth debating. However, I will remind you, the next time you have a layoff or you have a situation where you're trying to decide who to let go, the ones who refuse to fill this out should be top of your list. There's a problem and there's a reason they don't want you to know, and that's fine. They're already hired, they're working for you, we'll go with that. But just know there's a reason, and that reason may not be in your interest. The form itself is meant for a post-offer capacity. So what you're looking for are the flags. You'll find the flags 3/4 of the way down on the first page, which talks about injuries. About 3/4 of the way down, all the way through, and onto page 2, just above the all-cap final paragraph. All of those points in there are important to look at to see if you see any flags or issues like prior claims, prior surgeries, prior physical problems. Now, can you make a decision because you see it? And should you? No, on both counts. Neither case should you, but it's a flag. It raises a concern for you to say, I need to have my doctor examine you to see if you can do this job. The job has a 50-pound limit. The doctor you want to set up at a clinic nearby who can do a stress test. This is not a physical exam per se. It is a physical stress test on a machine that will test this person's ability to move, bend, twist, and handle weight limits that you designate. If the doctor deems this person unable to do this without injuring themselves, they will tell you, and that's what you need to know. The doctor is the one who must tell you you cannot hire them. Now, you can ignore the doctor. You may have other reasons to hire them, but do so at your own peril, because you're setting yourself up for a possible problem that may very well surface, and you could be the fixer. Do you want to do that? You say, yeah, but the test is going to cost me $40 or $50. Remember, the claim from this will be $40,000 or $50,000, and you'll get to pay it back 3 times over 3 years, and that is painful. The $40 or $50 is the best bargain you'll ever find. Set it up, make the doctor aware of what your concerns are, what your weight limits are, and use this form the way it's designed, okay? The form is there for a reason. Next on this form, point out one other fact. If you look at page 2 at the bottom in the paragraph in all caps, in summary, what that says is to the employee or the applicant who fills it out, it says if you lie on this form and you fail to disclose physical conditions, and then you have a work comp claim down the road, and what you fail to disclose is directly related to your injury, your claim will be denied. The adjusters will immediately do a full medical background check from the time you were born. They will know everything about you medically. And why can the adjusters do it? Because they know workers' comp is granted immunity. You have no privacy with workers' comp. So they need to tell the truth on this form so you can make a rational judgment. If they think they're going to succeed by lying on this form and then they have a claim and they bring an attorney, the judge will tell the attorney, I'm sorry, but your plaintiff lied. You cannot lie to an employer and set them up. They wouldn't have hired him, or they would have had him checked out had they known that. And that's what will happen 99 times in 100. Nothing in this life or in workers' comp is ever 100% all the time, but most of the time that's what's going to happen. The form is very helpful, it's beneficial, it's meant to protect you and give you a way to go on offense up front. If you don't go on offense, you will be playing defense on comp indefinitely, and you will lose. You can't win unless you score. We've got to score somewhere. This form is important. We'll move to the next form and the last form in the packet, which is the final statement on work accidents. This form is very simple. Do the best you can with it. Nothing is ever perfect. When an employee leaves your employment, for whatever reason, they choose to leave, they're fired, they're terminated, whatever the reason, do the best you can to get this form filled out to have it on the record. It is important you know when they left, and you have it signed and dated by them when they left, if they were hurt or not hurt. The states are going to grant an employee 1 year to come back and file a claim on you from the time they leave. And the burden of proof is on you to show when they left you they were okay, or they had a claim and here's exactly what it was. They don't have to prove anything, and their attorney will be sure They will just file it and it will be accepted unless you can disprove it. Without paper and comp, you have nothing. You don't have to like it, you just have to accept it. Do the best you can. Make that exit interview. Make them come in for that last check in person. Don't issue any direct deposits if you can. There will be times you will not be able to get the form, but do the best you can. That's all you can do. We've covered the group of this forms on employee pre-hire, application, and hiring. It is important that you take action and go on offense, as was said. Just know that this is the beginning process of a somewhat longer process as we change the workplace culture and bring you into a climate and an environment that will allow you to avoid banging your head in the wall or breaking your nose like John in the same place. That's what it's about. Thanks for taking the time. We'll talk to you the next time.